Hi, this is Alexia Dominguez from Smith Dominguez, and today Ajane and I will be bringing you some COVID-19 updates as it relates to the court system, your case, and our firm. Last week, Chief Justice Beasley issued a new order in response to Governor Cooper's stay-at-home order. In her order, she gave out several directives that affect the way that the court system is functioning now. If you would like to read the entire order yourself, you can visit the NC Court's website. Now, Ajane is going to break down the directives.
Hi, it's Ajane here, and today we're just going to break down the emergency directives from the Chief Justice order. So just to start, the most important part for many people is that all Superior and District Court proceedings are going to be postponed until June 1st. This means that the case can go on if it's going to be remote or if there's a due process of law issue or for emergency relief, such as for restraining orders or domestic violence or an emergency custody hearing. Also, there are other exemptions that are up to the Superior Court judges and the chief judges of the different courts. And, we have to always make sure that everyone's safety is taken into account first and foremost. In addition to that, if you have been around someone who has been exposed to COVID-19, you yourself have been exposed, or you think that you may have any of the symptoms, please avoid going to the courthouse. If you have business before the courts, you should contact the clerk by their phone number, which is found on the court's website as well. And you can search that by the individual court that you need. Let the clerk know what's going on and what you are supposed to be at court for, and they will let you know how to proceed from there. And then most importantly, make sure you take care of yourself and contact a healthcare provider. The next directive discusses more of what we talked about in the first part with the court hearings being postponed. There are certain statutes that do not allow recordings, and if this is the case, those are the cases that will definitely be pushed back unless they're another standing emergency or constitutional issue. Judges can allow video or remote proceedings to take place only if there's consent of the parties, or if it's a criminal case, the defendant waives their right to having an in-person confrontation, or the proceeding needs to be recorded. There are other issues here and other more specific examples, so please reach out to an attorney to find out if this is what you may want or need. The next directive is that any attorney who doesn't have to be at court should not be at court. So in this case, this could affect you because attorneys are recommended to mail their filings. A lot of times, attorneys will just go to the courthouse, which can kind of give you a quick turnaround. Now that you have to wait for documents to be mailed to the clerk to be documented and stamped, in many cases, this can prolong the time before you're filing. So just be open with your attorney and ask questions if necessary and see how this can affect you. The next directive can be, in a way, it can be kind of convenient for folks because any pleading, motion, petition, affidavit, or other document that has to be filed in the court or an oath that has to be taken, you do not have to have it notarized. And all you have to do is add an affirmation to the document. Now, this doesn't apply to wills or real estate conveyances or transfers or any other thing. So things that are filed with the Register of Deeds, it only applies to court filings, but this is something that can really help people so that way you can limit the amount of contact that you have to have. Next, documents be served by email. So this means that both parties have to consent to having email service. This will allow for you to avoid having in-person sheriff service for important types of filings. The consent must be in writing but everything must also still be emailed before 5 o'clock p.m. to be considered served on the day that it was sent. Next, any person who owes money for a judgment or has traffic court payments that are due or other types of payments to be paid to the clerk, and there is a failure to pay, there is a 90-day extension for non-payment. The clerk will not notify the DMV that you have not paid until after this time ends.
This order by Chief Justice Beasley does not replace previous orders issued in regard to the court system and the COVID-19 outbreak. If you have any questions, feel free to reach out to us at smithdominguez.com, where you can schedule a consultation or shoot us an email with any questions you might have.